Kurt Fried and Robert Ingersoll are an openly gay couple that have been regular customers at Arlene's Flowers for about a decade. Last year, Washington State passed a gay marriage law, and in response, Ingersoll approached Baronel Stutzman, the owner of Arlene's Flowers, and said that they were going to be married. Before he even had a chance to formulate his request, Stutzman replied, "I'm sorry, I can't do the flowers for your wedding because of my relationship with Jesus Christ." In response, the state attorney general, Bob Ferguson, filed a consumer protection lawsuit against Arlene's Flowers to compel Arlene's Flowers to provide flowers for this and other gay weddings. The filing of this lawsuit marks the death of freedom of religion in Washington State. Now, before I demonstrate this or prove this audacious claim, what is freedom of religion anyhow? Some would say that it's the freedom to believe anything you want to. However, this definition is too shallow because there's no way to tell what a person believes except by what they say and by what they do. Now, freedom of speech protects what a person says. For freedom of religion to be worth anything, it has to protect what a person does in service or duty to a God or higher being, whatever that person perceives them to be. Now, freedom of religion, like any of the other freedoms, is not unrestricted. It can be restricted by the state if the state can demonstrate a compelling state interest in doing so. So, does this case meet the test? Now, the gay couple wanted flowers for their wedding. Did they get what they wanted when they wanted it? Of course they did. The only thing is they didn't get it from their vendor of choice. So what is at stake here? The gay couple were outraged. They were humiliated because they couldn't get flowers from this vendor. So can freedom of speech be curtailed by the state merely because a person is offended or outraged by what a person says? Of course not. Neither can freedom of religion be curtailed merely because a person is offended or outraged by what a person does. So now, if this is such a grievous violation of freedom of religion, wouldn't it be like, a little bit more obvious to everybody? The answer is no, because oppression only seems like oppression by those who are oppressed by it. Now, let me give you two examples. No taxation without representation. So they fought a war and ended taxation without representation, right? Of course not. Women did not have the vote, so they have no representation. The fathers of the revolution were only trying to end taxation without representation of men. They saw nothing wrong or inconsistent with taxation of women without representation. An even better example is the Declaration of Independence lists 27 grievances against King George III and the British government, justifying why they were going to throw off the yoke of British tyranny. Now, how could all of these grievances put together compare with the great injustice of being a Negro slave in the American colonies? Couldn't the Revolutionary War fathers see that their grievances against England were as nothing compared to the situation that the slaves were in? They could not, because they were not Negro slaves. Now, I'm hoping at the end of this talk that you can see the case through the eyes of Baronel Stutzman. There are many people who would fight tenaciously to defend their religious freedoms, but they're silent on this case because it's not their religious beliefs that are at stake. Now, there have been a number of intrusions on freedom of religion. There have been other cases that are similar to this, but this case has three features that make it a defining case. The first is, who's prosecuting it? Now, if a discrimination case came to the state attorney general, he would refer the case to a federal, state, or local civil rights agency. But he's not doing that. Instead, he is jumping in and prosecuting this case not as a civil rights case, but as a consumer protection case. So he is setting up a special and unusual prosecution for this case. Next, it is provable that this case has absolutely nothing to do with discrimination based on sexual orientation. Now, the gay couple had been customers from Arlene's Flowers for a decade, and sexual orientation has never been an issue. They've never felt uncomfortable. She's never denied them service. Likewise, Arlene's Flowers has had openly gay employees, and it's never been an issue. It has only become an issue when Arlene's Flowers was required to violate Stutzman's religious beliefs, to sin, and to provide flowers for what in her mind was a blasphemous copy, a vile copy of a religious sacrament, the sacrament of marriage of her own church. In this case, she said, I cannot sin against God. So it's not a case of discrimination based on sexual orientation. She does not want to participate in a religious ceremony that she doesn't believe in. Now, you can't describe Hinduism as just a bunch of superstitious nonsense and wipe away the freedom of religion of Hindus. Neither can you take Stutzman's sincere religious beliefs, label them as bigotry, and wipe away her religious freedoms as well. The third factor is that the Washington State Constitution is much more protective of freedom of religion than is the federal one. The state constitution does not just protect freedom of conscience. Article 1, Section 11 says absolute, again, absolute freedom of conscience in all manners of religious sentiment, belief, and worship shall be guaranteed to every individual. So we have on one side absolute freedom of conscience, and on the other side we have being forced to, in her mind, sin and participate in a vile sacrament of her church. I cannot think of a more grievous violation of freedom of religion than that. Now, whether gay marriage is legal is an issue for the legislature. Whether it is moral is a religious issue that cannot be decided by the state or enforced by it either. At issue here is not whether Stutzman must obey the law, but whether the state attorney general must enforce whether he has to obey the Constitution. Any law or interpretation of a law that violates the Constitution or constitutional protection is unconstitutional. But in this case, we are seeing the state attorney general using the full power of government to crush a critical constitutional protection while acting under color of law. Wars have been started over less provocation than this. So what is really happening in this case anyhow? Is the state attorney general jumping in on this case because there is such a critical shortage of flower vendors that if Stutzman doesn't provide flowers, that gay weddings will be without flowers? Hardly. What is happening here is that the state attorney general is saying that I have the right view on gay marriage, and Stutzman has the wrong religious view on gay marriage. And she must be punished for having the wrong religious beliefs about gay marriage and be forced to abandon her belief by violating the very beliefs that she has so that her actions align with the beliefs of the state attorney general. See, The State Attorney General views Stutzman as a heretic. This is nothing more than a heresy trial, trying to force a heretic to align with the, correct doctrine. Perhaps to show their support, Stutzman's supporters should wear buttons or shirts that say, "I too am a heretic." Now, I have said that the filing of this case, just the mere filing of this case, marks the death of freedom of religion in Washington. Now, isn't that a little premature when this case hasn't even come to trial? Well, if the highest legal authority in Washington can use the full force of government to prosecute a heresy trial, and he is allowed to do so by the citizens of Washington, there is no such thing as freedom of religion in Washington. All that looks like it's freedom of religion is areas that have not irritated the state enough to justify prosecution yet. Now, maybe you don't see your religious beliefs as being all that important enough to justify trying to defend them. But if we wipe off a critical constitutional protection like freedom of religion, are we going to stand as other constitutional protections are wiped away? What about freedom of speech? What about freedom of the press? What about the right to a jury trial? What about the right to a trial at all? But then, in the long run, isn't whether we mow the lawn or shop for groceries more important than whether we live as slaves or free men? In 1923, Adolf Hitler tried to seize control of German government by force. After some bloodshed, he was defeated in his beer hall putsch and spent about 8 months in jail. Now, this whole experience opened his eyes, and he determined that never again would he try to seize power by force. Instead, he would only do everything legally. And so, even as he came to power and became the absolute dictator of Germany, he did not abrogate or overturn the Weimar Constitution and its constitutional protections. He merely ignored them. If we do not stand and defend our constitutional protections, we will be ruled by a Führer and protected by an empty constitution. Thank you.